All right, so here's the next day, and we were reading about tender payment. I'm going to go ahead and share screen. I'll try not to read too much because it's a lot of information, and I don't want these to be extra boring. And I don't really know how to make this bigger. If anybody knows how to make it extra bigger, let me know. Because on the videos, they kind of look blurry and they look small. So let me see. Look at this. Oh, wait a minute. Plus. Yeah. I just figured it out. It's cool. All right. Let's see if I can do this. All right. Number 3, keeping the tender good. Regardless of the effectiveness of the maker's, me, original tender of payment, an additional requirement generally existed at common law that the maker had to keep his tender good or open. In Fitzgerald versus Vaughan, the Georgia Supreme Court wrote, a tender to prevent the running of interest must be continuing. The fact that a tender is made and refused is not sufficient to stop the running of interest. Let me read that part again. A tender to prevent the running of interest must be continuing. The fact that a tender is made and refused is not sufficient to stop the running of the interest. It must also appear that the tender has been kept good by the tenderer being at all times ready, willing, and able to pay the amount tendered. Oh. The rationale for requiring the maker to keep his tender good was that after the date of the note's maturity, the money legally belonged to the holder. Since the maker's obligation did not cease until the note was collected, the maker had to demonstrate the seriousness of his offer to pay by keeping the tender good. 2 exceptions to the necessity of keeping a tender good arose at common law. In a court of equity, it generally was not a fixed requirement that the tender be kept good, unless the maker sought affirmative relief from the note. The rationale stemmed from the equitable principle that a party coming into equity for affirmative relief must himself do equity. You know that maxim about equity? It's right here. So this is that rationale that stemmed from the equitable principle. This is that principle of equitable, it says right here, this is that maxim of equity, that a party coming into equity for affirmative relief must himself do equity. Let me go down here to, okay. Oh, okay, so they're doing the annotations of the cases on the bottom down there. Maybe you could take a snapshot if you needed to see them. I'm trying to save my voice because when I'm reading at nighttime, it gets a little scratchy. Okay, so now the second exception to the necessity of keeping a tender good was that the discharge of a surety was not dependent upon the continuing tender of the maker. The Supreme Court of Indiana in Spurgeon versus Smitha stated, a creditor impliedly undertaker, that the debt may be paid at maturity, and if he refuses to accept the money due when tendered him. Oh, okay. So they're trying to say that the creditor is the person that's the one that's owed the money, but that just seems backwards to me. How weird. A creditor impliedly undertakes that the debt may be paid at maturity, and if he refuses to accept the money due, why would you refuse to accept the money due? When tendered him, he breaks this implied undertaking and loses his claim upon the sureties, for the act is injurious to them. I don't understand that. I want to read it again. A creditor impliedly undertakes that the debt may be paid at maturity, and if he refuses to accept the money due when tendered him, he breaks this implied undertaking and loses his claim upon the sureties, for the act is injurious to them. How could the maker keep his tender good? By far the most common procedure was to allow the maker, here we go, to deposit the money due on the note in court. Oh. That means something, because the prior reading, it says something about the district court clerk and depositing the money. So by far the most common procedure was to allow the maker, me, I'd be the maker of the tender, to deposit the money due on the note in court. There's a reference, it's 34. It says Wallace versus McConnell, 38 US 13 petition. Is that what that is? 136, 140, 1839, Bank of Lafayette. Giles 674, 69. C note, tender, payment of into court. Yeah, we need to look at that. I want to keep reading and it's getting hot now. Whew. Good, I have a shirt on underneath. Whew, scary. For a second, I thought. I didn't. See, I'm getting hot. I don't know why. All right, so many jurisdictions impose such a profert in curia as an additional requirement for an effective tender. The Colorado Supreme Court. Are you shaking? Are you shaking something over there, Karma? What does this say? In order, however, to render this plea of tender effective. Oh, is that what they say? How do you plea? That's weird. In order, however, to render this plea of tender effective. That's interesting. Huh. They're calling it a plea, that you're rendering this plea, rendered, to tear this plea of tender effective when permissible. It would be necessary that it be accompanied by the tender and actual payment into court, subject to the plaintiff's disposal of the money admitted to be due. The equity courts, let me see if I can get it. The equity courts, what? Maybe I have to reduce this so I can, how do I reduce it? So I can see in there. Oh, there we go. I was chopping off the top. The equity courts did not impose the requirement that the money actually be brought into court. Not all jurisdictions imposed upon the maker the duty of bringing the sum into court. And down here in 37, it says, is that New Hampshire Rev State and 515.1 1974 provides at any time before the return day of the writ. Whoa, the writ. At any time before the return day of the writ, the defendant may tender to the attorney who brought the action the amount of the debt and costs, and such tender shall be a bar to any further proceedings in this case. I was going to keep reading. 39 on the bottom there, it says the states, Pennsylvania state and Title 12-1073, Purdon 1953 states, provided that the said defendant or defendants shall be required to keep up said tender at every trial of the action aforesaid, and may pay the money into court on leave obtained, but shall not be required to preserve or pay in the identical money originally tendered. What is it? What? You want something? All right, gotta pause for a second because the child. Well, hang on a second. I'm assuming that I'm paused right now. We'll find out. What do you want? Look, I don't want you to go out there because there's maybe coyotes. So I'm just saying. You cannot just go out there, you know? I have to go with you. Going to the neighbors. Good girl. Oh, what are you chewing on that? Okay, that's a good girl. Good girl. Yay, you're cute. It's chilly out there. Okay. All right. Where were we here? Oh, I don't know where we were. Okay, I'm back. So I don't remember where I was. I was reading something and it was down here. So, okay, so up here. Irrespective of the method of keeping the tender good, the maker had to keep the funds in readiness to pay the holder. Oh, is that why they say bring your checkbook to the lawyer? I don't know. The maker could substitute other funds for those originally deposited. As long as the amount on deposit did not drop below the amount owing to the holder. Two advantages attended a deposit in bank over a deposit in court. First, a deposit in court was generally held to be an admission by the maker, that would be me, that the sum tendered was actually owing to the holder. That's what I'm saying. I don't owe you guys jack. Don't want to pay you nothing, you pedophiles. Okay, 41. Yeah, I don't need to go there. If the maker had an assertable defense against the holder, a deposit in court would be unwise. Oh. Right. That's why it's confusing to me when they're like, accept all the charges, here's the money. But then you're saying I'm guilty. I didn't do anything wrong. I'm just saying that's what I'm saying. Doesn't make sense to me either. If the maker, that would be me, you're tendering payment, had an assertable defense, I don't know you jack, against the holder, you court traffic services, I don't owe you anything, then a deposit in court would be unwise. Second, if the maker, me, wished to substitute money, you want some Monopoly money? I got some of that for you. Or its equivalent for the sum originally tendered, that would be a check or money order or credit card. A deposit in bank would allow easier access to the money. A deposit in bank, however, raises an issue not directly faced by the courts. Who is entitled to the interest earned on the deposit while a tender is being kept good? I just saw a video, where was that? PJ sent me a video from Instagram. Let me see, what's the name of this lady? On Instagram. Let me see. Meta, what's up with that? Okay, come on. Terry Inc.
Okay,
from
you guys,
Nashville,
I'm sorry.
Tennessee.
I did not notice that the video had cut out. My phone is being raggedy, so let's try this again. I got a statement in the mail from Capital One stating that I had a bill due of $649.91. Again, it's a positive balance. You cannot pay on a positive balance, although all of these years, many of us have. So, for my proof, I went to Chase Bank and deposited my coupon that was attached here. You see, I ripped it here. I detached it, and I deposited into my bank account for $649.91. And again, you guys see, $649.91. I could have made it out for $175, but I went for the full amount. And proof shows here, it was today. So the information that I give you guys, I want you to know that I'm actually applying it and I'm teaching you based off of what I know. The proof is in the pudding, you guys. $649.91, $649.91, or $649.91. Make sure you guys keep these statements. Again, it's not a bill, it's a check.
Okay, so I thought that was interesting. She's saying that the bottom little coupon thing, when they send you something, the bottom part is a check. Well, I looked at mine and it looked like they have the amount and they have these little squares that are empty and you're supposed to fill it in, and then you send your check to Verizon or whoever it is. She was saying that that's a check. I'm like, is that what they're talking about right here? A deposit in bank, however, raises an issue not directly faced by the courts. Who is entitled to the interest earned on the deposit while the tender is being kept good? Is this that? That's what I'm wondering. If the maker tendered his debt into an interest-bearing account or a certificate of deposit, excuse me, the deposit would be earning interest. Yeah. The holder could argue that he is entitled to the interest because, oh, this is where that OID thing comes into play, I think, right here, the original issue or discount. It's going to be having interest on there. Okay, so the holder could argue that he is entitled to the interest because he is the legal owner of the money in the account. The holder could have collected the funds at any time and then invested them to return interest. The maker, on the other hand, could argue that the holder should not be allowed to profit from his own delay in collecting on the obligation. True. Further, if the effective rate of interest earned by the account or certificate of deposit is equal to or greater, are we doing math here? Is equal to or greater than the interest rate on the note, a primary purpose of the tender is destroyed. If the note is payable at 6%, wait, how do I move to the next page here, folks? I have to reduce it. And then I have to, yeah, I guess so, okay. Interest, and the maker tenders the principal and interest into an account bearing 6% or more interest to allow the holder to take the interest would be equivalent to allowing interest to accrue on the note after the date of tender. Yeah, I can see that. I just was wondering, what is this with depositing stuff in the bank after seeing that interesting video? In McCrae versus Martin in Ohio, the holder, that would be the person who got the, the check or money order, delayed presentment for 6 years. What? Why? And the maker used the money due on the note in his business. In awarding costs and interest to the holder, the Ohio Supreme Court stated the money due on the notes belonged in equity to the plaintiff. And though the defendant might hold it for his own indemnity, he so held it as the trustee of the plaintiff. Interesting. Instead of holding it without use, he put it into his own business and used it as his own, as if it were borrowed money. And failing to account for the profits, should upon equitable principles be held liable for the use of the money. This is heavy duty accounting stuff, big time. What happened? Okay. Under such a trustee theory, oh, that's the trustee theory, the interest earned by a deposit in bank. Oh, that's interesting. You know that video I just showed you? I wonder if when she deposited that in her bank, well, it really belonged to Citibank or whoever. She's saying it was a check, but I have a feeling when she deposited it in the bank, it's going to be, if I don't know that she has an interest-bearing account or what, but that's interesting. Her technique, I don't know. That's maybe what's going on right here. She's becoming the trustee. That she owes them, Citibank or Chase. No, she has a bank account in Chase. She owed Citibank the money, but she put that money, like that coupon thing, she put it in the bank, her bank. So I'm wondering if she's being the trustee. The interest earned by a deposit in bank would logically go to the holder, right? The result, however, renders the maker a caretaker of the holder's money. Arguably, giving the interest to the maker will promote prompt collection of negotiable instruments, since holders will have greater incentive to collect their money if it is in their responsibility to invest it. 4. The effect of a valid tender of payment. If the maker managed to meet the several common law requirements of a tender of payment, the holder was put on notice of the maker's readiness and willingness to discharge his debt. Wait a minute. Hold on a second. If the maker managed to meet the several common law requirements of a tender of payment, the holder of that, note or promise to pay was put on notice of the maker's readiness and willingness to discharge his debt. I don't get it. Huh? The result of an effective tender was the suspension of further liability for interest and costs accruing on the note after the effective date of the tender. Tender thus removed the possibility of further damage caused. What happened? What did I just? Okay. Caused by the holder's failure to make a timely presentment of the instrument for payment. But it did not excuse the maker from liability for the original principal and interest on the instrument. I'm gonna have to just watch this video over again and hear this again. I don't want to keep reading it over and over. Another consequence. This is a bad thing. Another consequence of a valid tender by the maker was the discharge of parties who had backed up the maker's obligation to pay by signing the instrument as sureties. If the holder refused to accept the maker's tender, excuse me, all sureties would be discharged. Wait, if the holder refused to accept the maker's tender, oh, this is good, because I did send in a money order to Verizon and they are the holder. If the holder refused to accept the maker's tender, that would be that, all sureties would be discharged. Whoa, yeah, from further obligation. Right there. That's perfect. I like this one. This rule was a corollary of the rule that a tender need not be kept good to discharge sureties. I still don't understand about the bank thing. I don't get that. This is like tonight was the first time I ever seen those little payment coupons as a check to put it in the bank. Maybe it's this keeping, I don't know, maybe it's the trustee theory. You know, maybe that's the trustee theory is what I think. Maybe she's doing the trustee theory. But the one I did was down here, another consequence of a valid tender by the maker was the discharge of parties who had backed up the maker's obligation to pay by signing the instrument as sureties. Okay, wait. Another consequence of a valid tender, that would be me doing something by the maker, was the discharge of parties who had backed up the maker's obligation to pay by signing the instrument as sureties. If the holder refused to accept the maker's tender, all sureties, that would be the living woman, would be discharged from further obligation. I like this one. This is good. This rule was a corollary of the rule that a tender need not be kept good to discharge sureties. A final consequence of tender of payment at common law related to constructive tender of notes domiciled at a bank. Oh, maybe what this lady was doing is she's domiciling it at a bank. That's maybe what she's doing, her method. The question arose, I don't know, just guessing. The question arose whether a valid constructive tender would excuse the maker from liability for the principal and interest on the instrument in the event of a bank failure. The issue came down to who should bear the risk of loss occasioned by the holder's failure to present the note before the bank failed. Okay, interesting. Well, like, you know, that money order that I sent, the those guys from, who was it, the CFO from Verizon, he's supposed to take that money order to the bank. So I'm wondering, he isn't doing it. He's saying, that's what he says. How can you tell with a money order? How do you know? How do you know that they cashed it? Because it's not like a check where they sign it and then you get a copy of it. So the argument for holders was that since Wallace versus McConnell requires no presentment for payment, the maker assumes all risk of loss as part of his obligation to pay the debt. Wood Company versus Merchant Savings and Loan. The argument for makers, on the other hand, was that the loss could have been prevented by the diligence of the holder, and thus it was unfair to place the risk of loss on the maker of the instrument. Makers, in essence, were arguing that bank domiciled paper, that's probably like what that lady did. She took the little coupon thing payment and put it as a deposit into the bank. That's what I'm guessing, because that's new to me. I don't know. And as in England, be treated like a check. in which case the holder is responsible for loss caused by delay in presentment. Common law favored the holder in the event of bank failure. Most courts followed the Wallace view of bank domiciled instruments. The debate, however, resurfaced under the negotiable instruments law and continued through the enactment of the code. C. Tender of payment under the negotiable instruments law. The negotiable instruments law, NIL, a uniform act widely adopted prior to the code, was the predecessor of Article 3. Several negotiable instrument law provisions directly affected the law of tender. 1. Presentment rights under the negotiable instruments law. Section 70 of the NIL, negotiable instruments law, codified virtually word for word the rule of Wallace versus McConnell, denying presentment rights to makers of negotiable instrument. Denying presentment rights to makers of negotiable instruments. NIL section 70 reads, all right, pay attention to this one because I'm getting tired. Presentment for payment is not necessary in order to charge the person primarily liable on the instrument. But if the instrument is by its terms payable at a special place, and he is able and willing to pay it there at maturity, such ability and willingness are equivalent to a tender of payment upon his part. Section 70, taken alone, would appear to codify the common law rule of presentment and provide for the possibility of constructed tender of domiciled instruments. Let me see if I can make this bigger so you can see it. But now I'm going to have to wait. Hang on. Did I do it? Confusion, however, was created by NIL section 87, which stated that when an instrument is made payable at a bank, it is equivalent to an order to the bank to pay the same. For the account of the principal debtor thereon. Section 87, in essence, required presentment for bank domiciled paper, which would be treated as a check. I think this is what that girl did, or that woman. The risk of loss on checks was set forth in NIL section 186. A check must be presented for payment within a reasonable time after its issue, or the drawer will be discharged from liability thereon to the extent of the loss caused by the delay. Section 87, read in conjunction with section 186, would apparently overrule the rule of Wallace. How do you say that? Overrule the rule of Wallace and McConnell set forth in section 70 for bank domiciled instruments and adopt the English check view of this type of negotiable instrument. So apparently these little coupon things are a type of negotiable instrument, which is what that lady said, was that it was a check. And she put it into her bank because they probably wouldn't have received it like I did, the money order. When you send it to them, they don't receive it. So that their law says, what's the sense of doing that when you can do what she did? Because they're not going to accept it anyways. Why waste your time? I like that. I should go to the bank tomorrow and see if I can deposit my Verizon coupon thing. I don't know. I better read some more. The issue thus became which NIL section would control section 70 I could just see the tellers now. They'll be like, this is not a check. Looks like you need to send this to the Verizon place. And you fill it out and you put it in an envelope and mail it to them with a stamp on it. Whoa. I had to test this theory and go over there and see if did they do that? Oh, now they have a new thing where you can actually take a picture of a check and deposit it with your phone. But I would want to know for sure. Maybe I could try that on my phone. That could be interesting. You know? That could be interesting. Okay, which apparently adopted the Wallace Rule uniformly, or Section 87, which apparently established a different rule for bank domiciled paper. The dispute over presentment rights and risk of loss caused by delay in presentment took on importance as banks failed during the Depression. Excuse me. I made some cranberry juice from cranberries. Someone gave me a bag of fresh cranberries, and then I put them in my Instant Pot with water and a little bit of sugar. And I just poured the water in my cup, and it's cranberry juice. And then I made jam with the rest of the cranberries, and it was good. Okay, so the dispute over presentment rights and risk of loss caused by delay in presentment took on importance as banks failed during the Depression. Holders were anxious to uphold the common law Wallace Rule, now lodged in Section 70, and place the risk of loss for bank failure on makers. Oh, Section 70. Taking a loan would mandate that the maker, that would be me, if she had sufficient funds on hand at the maturity date of the instrument and the bank failed. How does the bank fail? Be excused only from liability for interest and costs accruing on the instrument after the date of tender. This reading of NIL found great favor in the southern and western states, which ignored Section 87 and continued the common law tradition of placing the risk of loss on the maker. A minority of states, led by New York, favored the check theory of Section 87 and felt that it was unfair to place the risk of loss on the maker. I agree. Nevertheless, the majority rule, those Democrats, the mob rule, judicially resolved the statutory conflict in favor of Section 70 and continued to place the risk of loss on the maker. Okay, well, we're going to stop here because I'm getting tired, but I'm going to read number 2, secondary liability and tender of payment, for the next reading. Good night.